Alright, so let us continue, huh? And then there's a part in here. He quotes a statute, 18 USC section 521A. And I ask, what about the special order regarding 3 521 I had attempted to file in the court here in Dallas? And got two different references to a so called Special Order 3 521. I have not been able to find any reference to it. Is that in some way connected to 18 USC section 521? I see. It's been part of that. If it is, that would confirm some of my suspicions in terms of what ended up happening with my case, as opposed to my case actually being considered for the merits of the case. But then it goes on to discuss this from, if it was proven that there was an intent to issue that in 2020 so as to be available as an option for execution upon the assumption by Biden of the office of the presidency, then my charges on that matter would have been substantiated, especially insofar as there is the below 16 and not below 18, referring to how in the particular executive order of concern or the memorandum of concern, he discusses those under the age of 16 and not 18. Why? 18 is the legal age of consent. 16 would be the age where one would have their own driver's license. And at least in the state of Texas, that driver's license would include a contract number. Prior to obtaining your driver's license, you have a different kind of documentation about you personally. But the first primary documentation that could be allowed to be used to bond you directly outside of intercessing with or through a parent or a guardian would be one that would be issued to you legally, or that you would be legally eligible to obtain upon the age of 16 years old. And that goes in specifically into my allegations of securities fraud in the consideration of specifically minors in these kinds of actions. And then this also talks about another aspect about how this specific law that then speaks to the espionage and the licensing considerations, including insofar as California may be included in the Southwest. This goes into concerns I had with the National Director of Intelligence, who was from the northern Dallas area, that was appointed last year during a time frame wherein the state of Texas was non-compliant with laws regarding licensing for first-time drivers that allowed for young drivers and adult drivers to be put together when it came to certifications that were necessary to obtain in order to get a driver's license that was in flagrant violation of the actual law in the state of Texas and had been in violation for more than 3 years by the time the National Director of Intelligence was appointed from somebody who had previously served in Congress from the Northern District of Texas, meaning that in performance of his official congressional duties, including on the Homeland Security Committee, or the Committee for Homeland Security, he would have been apprised of the licensing situation in his home state and had failed to act. And then we get into this understanding of February 18th memorandum. It talks about the demands of public safety will make it impractical to obtain pre-approval for an at-large enforcement action. And I ask, what does at-large do to considerations of jurisdiction with regard to anticipated apprehension and or transport between jurisdictions? Why? Well, because later it talks about the procedural background. And in the procedural background, it specifically references a date of April 6, 2021. It says the states, meaning the state of Texas and the state of Louisiana, Louisiana being where the 5th District Court of Appeals, which covers the state of Texas, has its jurisdictional headquarters, its primary jurisdictional offices, April 6th of 2021. And what do I say here? This is 4 years to the day after I filed with both the Texas Medical Board and the State Bar of Texas. Their strategic removals from the DOJ OFAC derivative kingpin designation list that occurred at the time, and I contend are about using me and my reports for some other form of leveraging that violated my rights to due process and aided and abetted acts of retaliation against me. Is this connected to the charges against Juan Orlando Hernandez and his brother from this year? That is itself a derivative reporting on what resulted from that Citigroup hearing regarding private banking in 1999 that discussed the president of Mexico's brother that I was alleged was used in acts of money laundering by members of public office, including to frame political opposition in the U.S. This is a serious charge, and I know that. But if this is an actual literally what it's alleging to be. This is actually evidence of the specific strategic process I've been trying to draw attention to now actively for 5 years, but in some manner or another for longer even than that. Okay, then it gets to the constitutional considerations of the application of the Administrative Procedures Act. And then I say, when he's talking about the Constitution's requirement, the president, quote, take care that the laws be faithfully executed, count 6, which is presumably one of the counts that was presented. I said, sorry, this sounds totally like a revisitation of my claims that I filed in Texas. It goes to my review last night as specific state commissions being involved with racketeering, per the review of Stinson versus U.S. Were not these points brought up in by me when it came to detention of people alleged to need mental health observation, when what they were trying to do is submit reports to mandated reporters of fraud and child abuse, including in connection with concerns regarding abuse of office by the President of the United States per executive orders? So presumably this case is about the state of Texas and the state of Louisiana filing charges concerning an executive order that is attempting to compel people to engage in unconstitutional action, including in connection with abuse of the Administrative Procedures Act and other acts concerning detention of peoples. That's exactly what the charges were in my original writ of habeas corpus, except it was discussing alleged mental health observation, which I contended was actually being used as a form of political retaliation and an effort to try to obstruct actual criminal charges against crimes that were being committed through the Health and Human Services Network, including and especially connected to distribution of controlled substances. This is the third time, literally, that my case was subverted and ended up on time as a case allegedly brought by the state of Texas, including the case that went before the Supreme Court of the United States regarding taxation and the Affordable Care Act, as opposed to crimes committed in the course of misapplication of laws concerning people who had need of assistance from homeless and domestic violence shelters, as well as members of law enforcement and the judicial branch of government, but were trafficked under the auspices of healthcare instead. I spoke specifically about veterans and their families then, but then this is specifically, supposedly, about immigrants. Or, as he identifies it, criminal aliens, right? Which I do not think is an appropriate legal term to use in the context he's trying to communicate here. But then it discusses here just 12 days before the transition from the Trump administration to the Biden administration. And I say 12 years is also the general time frame between sunset reviews of specific commissions here in the state of Texas, which means it passes the 10-year mark for considerations of racketeering, as well as potentially completes a 2-year smoothing period. It would also be a 10-day executive compensation period with that 2 days to transfer through a new person detained but only held for the 48-hour period. So if your concern is that they're actually manipulating policy in order to aid and abet acts of securities fraud and trafficking people in connection with it, that's exactly how these timelines line up. That's exactly how he's presented it in terms of evaluation for one that is cognizant of those factors, including timelines in regards to such matters. And then it says here, it also talks about which also there, so we're concurrent. He says that there were concurrent filings in both the state of Texas as well as from the regarding the Louisiana Department of Justice on the same day, January 2021. And then I, reflect that Louisiana is where you would go for a Fifth Circuit Court of Appeals case, which brings up a question of the concurrent enrollment, or rather the concurrent filing process, and if in fact they're using these as derivatives, including in connection with overtly and deliberately attempting to subvert a process that was engaged through an effort at a criminal proceeding, including charges associated with racketeering involving the healthcare sector, then this is very concerning in that regard. Then it discusses here using the Administrative Procedures Act allows this court to review the memorandum challenged by the states. And I say I had requested a writ of certiorari in my case regarding specifically the racketeering charges. And I was told it was sent back with a letter, but that package was stolen before I was forced to transport myself with someone else's financial assistance out of the city and county to which the return package was to be sent. There was the specific opinion regarding emergency hearings concerning the status of people involved with deportation proceedings and the reference to bring cases before the local district courts. I also recently requested certiorari review from my cases from Dallas requesting new trial that were not permitted to be submitted to the Court of Appeals, but instead again referred back to Dallas, which I considered at the time to be an effort to compel a kickback. Then there was the August 16, 2021 order and judgment that has now been revealed to what? This is dated the third day after that. Is this an estate ruling? So on August 16, 2021, I got presumably an order and a judgment from the presiding judge in the case that had previously been considered before a magistrate judge in a manner that I contend was not appropriate and was illegal, that it was not suited for a magistrate judge. And those charges were a request for consideration of articles of impeachment of the Texas State Senate for its role in violations of the Texas Constitution, which have a material factor in consideration of what this is alleging in this opinion. And then this is talking about injury, traceability, and redressability comprise the irreducible constitutional minimum of standing. There's a specific case that's quoted. And then I ask, so the failure to state a claim for which relief can be provided means what before it has been considered for its merits? And see, they're talking about consideration of a case having merit. It includes identification of an injury, a traceability of the crime, and the redressability that is possible through a request for relief, right? And so he's bringing this up in this context. But then there's another situation here having to do with a citation of a case, and he abbreviates the case and refers to it as Texas DAPA, DAPA. Now, I ask, do you know what DAPA in Texas was before the database established around the Affordable Care Act? Around the time of the Affordable Care Act, there was a deferred access for parental arrivals, as well as the deferred access for childhood arrivals. My understanding is DAPA was, the database DAPA was decommissioned, but DACA still persists. However, there used to be a program here in Texas that was called DAPA, specifically, that had one mission several years ago, prior to the implementation of the DAPA database, and now has changed. That program is specifically connected to making available medications, including medications for those who have an alleged mental illness that are minors. This is a program here in Texas that has been around prior to the changes to immigration law concerning DAPA and DACA. So in this situation, specifically where he's talking about special solicitude that's being requested by the state and abbreviating the case into a context for consideration as Texas DAPA, this is very, very concerning. What is this special solicitude that is being attempted for consideration? And I ask this, and I say, and traceability in such a manner was specifically put before both the Texas Supreme Court in June of 2018 and the Supreme Court of the United States in December of 2018, as the Supreme Court of Texas was quashing my effort the same day it filed its own case regarding the Affordable Care Act with SCOTUS. That quashing was, I understood, not a legal act by the court. And then it goes up into so for the next one, this is a consideration are owed special solicitude, which would satisfy any doubts. He's talking about this consideration of this concept of special solicitude and any doubt about its legitimacy. And I say, how does quasi-sovereign, definition of a quasi-sovereign entity, how does quasi-sovereign comport with understanding the sovereign will of the people when it comes to immunity of the state from prosecution? There's specific case considerations here in the state of Texas regarding the sovereign will of the people as being demonstrable in a claim regarding the immunity of the state. So I'm going to go ahead and end this one, and I'm almost finished here.